Mercado vs. Manzano. GR number 135083, May 26, 1999. Facts: Ernesto Mamarial filed a disqualification case against vice mayoralty candidate Manzano on the ground that he is not a citizen of the Philippines, but of the United States. In its resolution, the Second Division of the Commission on Elections granted the petition of Mamarial and ordered the cancellation of the certificate of candidacy of Manzano on the ground that he is a dual citizen and under Section 40, Paragraph D, of the Local Government Code and the Makati Charter, persons with dual citizenship are disqualified from running for any elective position. The Commission found out that Manzano was born in 1955 of a Filipino father and a Filipino mother in San Francisco, California, in the United States. Hence, he is an American citizen following the jus soli rule, and at the same time, a Filipino citizen for being born of Filipino parents.
Manzano filed a motion for reconsideration. Pending such motion, the 1998 elections was held, and Manzano garnered the highest number of votes for vice mayor in the city of Makati. His proclamation was suspended, pending resolution of the case. Petitioner Mercado, who garnered the second highest number of votes to Manzano, intervened in the disqualification case. Without resolving Manzano's motion, the Commission on Elections and Bank reversed the ruling of the Commission on Elections Second Division, and declared Manzano qualified to run for vice mayor. Hence, Mercado filed a petition for certiorari to the Supreme Court, seeking to set aside the resolution of the Commission on Elections and Bank. This is a petition for certiorari seeking to set aside the resolution of the Commission on Elections and Bank, and to declare private respondent disqualified to hold the office of vice mayor of Makati City. Petitioner contends that the Commission on Elections and Bank erred in holding that Manzano was no longer a U.S. citizen when he renounced his U.S. citizenship by registering as a voter and voting, and that Manzano is qualified to run for and hold the elective office. Issue number 1, whether or not Mercado has the legal personality to bring this suit considering he was not an original party in the disqualification case filed by Ernesto Mamarial. Held, yes. Section 6 of Republic Act No. 6646, otherwise known as the Electoral Reforms Law of 1987, provides:
any candidate who has been declared by final judgment to be disqualified shall not be voted for, and the votes cast for him shall not be counted. If for any reason a candidate is not declared by final judgment before an election to be disqualified, and he is voted for, and receives the winning number of votes in such election, the court or commission shall continue with the trial and hearing of the action, inquiry, or protest, and upon motion of the complainant or any intervener, may, during the pendency thereof, order the suspension of the proclamation of such candidate whenever the evidence of guilt is strong. Under this provision, intervention may be allowed in proceedings for disqualification, even after election, if there has yet been no final judgment rendered. Issue number 2, whether or not dual citizenship is a ground for disqualification. Held, no. To begin with, dual citizenship is different from dual allegiance. The former arises when, as a result of the concurrent application of the different laws of two or more states, a person is simultaneously considered a national by the said states. For instance, such a situation may arise when a person whose parents are citizens of a state, which adheres to the principle of jus sanguinis, is born in a state which follows the doctrine of jus soli. Such a person, ipso facto, and without any voluntary act on his part, is concurrently considered a citizen of both states. Considering the Citizenship Clause, Article 4, of our Constitution, it is possible for the following classes of citizens of the Philippines to possess dual citizenship. Number 1. Those born of Filipino fathers and or mothers in foreign countries, which follow the principle of jus soli. Number 2. Those born in the Philippines of Filipino mothers and alien fathers, if by the laws of their father's country, such children are citizens of that country. And, number 3. Those who marry aliens, if by the laws of the latter's country, the former are considered citizens, unless, by their act or omission, they are deemed to have renounced Philippine citizenship. There may be other situations in which a citizen of the Philippines may, without performing any act, be also a citizen of another state. But the above cases are clearly possible, given the constitutional provisions on citizenship. Dual allegiance, on the other hand, refers to the situation in which a person simultaneously owes, by some positive act, loyalty to two or more states. While dual citizenship is involuntary, dual allegiance is the result of an individual's volition. In including Section 5, in Article 4 on citizenship, the concern of the Constitutional Commission was not with dual citizens in itself, but with naturalized citizens, who maintain their allegiance to their countries of origin, even after their naturalization. Hence, the phrase, dual citizenship, in Republic Act No. 7160, Section 40, Paragraph D, and in Republic Act No. 7854, Section 20, must be understood as referring to dual allegiance. Consequently, persons with mere dual citizenship do not fall under this disqualification. Unlike those with dual allegiance, who must, therefore, be subject to strict process with respect to the termination of their status. For candidates with dual citizenship, it should suffice if, upon the filing of their certificates of candidacy, they elect Philippine citizenship, to terminate their status as persons with dual citizenship, considering that their condition is the unavoidable consequence of conflicting laws of different states. Issue number 3, whether or not Manzano is disqualified to run. Held. No. By filing a certificate of candidacy when he ran for his present post, private respondent elected Philippine citizenship, and in effect renounced his American citizenship. The filing of such certificate of candidacy sufficed to renounce his American citizenship, effectively removing any disqualification he might have as a dual citizen. By declaring in his certificate of candidacy that he is a Filipino citizen, that he is not a permanent resident or immigrant of another country, that he will defend and support the Constitution of the Philippines and bear true faith and allegiance thereto, and that he does so without mental reservation, private respondent has, as far as the laws of this country are concerned, effectively repudiated his American citizenship and anything which he may have said before as a dual citizen. On the other hand, private respondent's oath of allegiance to the Philippines, when considered with the fact that he has spent his youth and adulthood, received his education, practiced his profession as an artist, and taken part in past elections in this country, leaves no doubt of his election of Philippine citizenship.